Today, we will talk about attorney-in-fact, definition, types, powers, and duties. An attorney-in-fact, also known as an agent, is a person authorized to act on behalf of another person, called the principal. This is typically done to handle business or official transactions. The principal usually designates someone as their attorney-in-fact by granting them power of attorney. An attorney-in-fact is appointed through a legal document called a power of attorney, which gives them the authority to make decisions and take actions on behalf of the principal in various legal and financial matters. The attorney-in-fact is not required to be a lawyer, but they must act in the best interests of the principal and follow any instructions or guidelines set forth in the power of attorney. Depending on the type of power of attorney granted, the attorney-in-fact may have broad powers to manage the principal's affairs, such as opening and closing bank accounts, paying bills, and making financial decisions. It's important for the attorney-in-fact to act in the best interests of the principal. An attorney-in-fact is not the same as a lawyer or attorney-at-law. While an attorney-in-fact is authorized to make decisions for the principal, an attorney-at-law offers advice and can represent a client in court, but does not make decisions on their behalf. A durable power of attorney allows the attorney-in-fact to continue making decisions for the principal, even if the principal becomes incapacitated. It's important to consider naming successors in case the original designee is unavailable or unwilling to assume the responsibility. An attorney-in-fact can be designated for convenience, to act on behalf of the principal in transactions when the principal is unable to do so, or if the principal is incapacitated and unable to make decisions for themselves. No, an attorney-in-fact can be anyone designated by the principal, such as a family member, close friend, or lawyer. There are no restrictions on who can be appointed as an attorney-in-fact. It's important to note that an attorney-in-fact is not the same as a lawyer or an attorney. A lawyer is a professional licensed to practice law, while an attorney-in-fact is simply a person who has been given the authority to act on behalf of another person. No, an attorney-in-fact is the person to whom power of attorney is granted. When making decisions on behalf of the principal, the attorney-in-fact is usually required to show the written document providing power of attorney as proof of their authority. As an attorney-in-fact, you are legally responsible for carrying out the duties and responsibilities assigned to you by the principal. If you fail to fulfill your duties, you may be held liable for any damages or losses that result from your actions or inactions. Appointing an attorney-in-fact should be done carefully, and the person chosen should be someone the principal trusts. Power of attorney can be general or limited to specific transactions and topics, and it only lapses if the principal dies, becomes incapacitated, or revokes it. Here are 4 key takeaways. 1. An attorney-in-fact is someone designated to act on behalf of another person, whether in business, financial, or personal matters. 2. An attorney-in-fact is designated through the granting of power of attorney, usually by the person who will be represented. 3. An attorney-in-fact need not be an attorney-at-law, which is another name for lawyer. The former makes decisions for a principal, while the latter advises and represents a client but is not involved in decision-making. 4. The person appointing the attorney-in-fact is called the principal, and the attorney-in-fact is sometimes referred to as the agent. Hope this would help. Thanks for watching.